Jeremy Rogers. Many of you know the Attorney General's office, specializing in open records and open meetings. We've got a quick one this morning, so we'll try to jump right into it because there's a fair amount of ground to cover, and we're only scheduled for 30 minutes. If you are accustomed to Zoom, it's a lot like Zoom, so if you have questions or comments, there should be a chat function on your computer, and feel free to type those up, and Amy's going to monitor that while I attempt to go through these slides and tell you what you need to know within 30 minutes about the changes to the law, the open records law, that take effect next Tuesday, the 29th. So they really fall into three different areas. There are limits on who can make requests, or more precisely on who can make requests that must be honored by a agency. There are additional requirements for requesters, forms and so forth, and for agencies. And then there are a few new exemptions to the open records law that take effect next week. We will start with the limit on the requesters. We call it here the new residency rule. I like to think of it as the old Kentucky rule because it's for folks who have a Kentucky home, although there are certainly broader parameters than that and some nuance to it. And for a lot of these things, I think what we're going to talk about is the fact that it's going to be a while before we know how these actually play out in practice, because these or will be learning these just as requesters. We don't know how the Attorney General and the courts are going to interpret some of these, so there will be a learning curve. So as I said, we started by saying this law takes effect next Tuesday. In terms of the residency rule, we are following now a pattern that a number of states, Amy, how many states have residency requirements?
About 8.
About 8 states. I know Tennessee, several limit, or at least they allow limits to those in the state. For the Kentucky rule that's taking effect, it's human beings, people who live or work in the Commonwealth. For businesses, those businesses that are registered or located in Kentucky, I think technically if you are a business and have any sort of office present in Kentucky, you should be in Kentucky. There are people and businesses owning property in the Commonwealth, and you'll see that if this was a Venn diagram, there would be a lot of overlap in many of these categories. Authorized representatives of residents, so the resident's lawyer, power agent, or times. And then the big carve out that's interesting is news gathering organizations. So the way that it works with this law, any news gathering organization, as long as it qualifies as a news gathering organization, whether it has a physical or other presence in Kentucky, will still be considered a resident for the purposes of
We're getting some folks ask people to please mute. We're getting some feedback, so please mute.
If you're on a cell phone, you'll need to dial *6 to mute.
Thank you. Might be a way for me to mute everybody. A person who resides in Kentucky, that's pretty easy. What's not going to be easy is to know how agencies are able to monitor or police this. There's really not, as far as I know, not any serious definitive guidance on how agencies will be able to verify if you really are a resident of Kentucky, or if you're a resident from somewhere else who is just saying that you are a resident of Kentucky. So stay tuned to see how that plays out.
Excuse me, someone needs to mute their phone. Please mute your phone. When you walk and you drive, that can be heard. Please mute your phone, *6.
Thank you. And we say residency requirement, but it's also for those who work in Kentucky. So we're here in Louisville. You can't see on the video because we've got the PowerPoint up, but if you look out the window to my left, I can see the state of Indiana right across the Ohio River. And a great number of people live in Indiana and come over here to work during the day. They would qualify under the residency requirement. And if you see at the bottom of your screen, we talked about the news gathering organizations earlier. The statute, if I'm not mistaken, Amy, KRS 189-635, that's the statute that applies to traffic accident reports. Right. So for years and years, there's been a carve out where for the police traffic accident reports, they're not generally publicly available. They're available to the accident victims, the lawyers of the victims, insurers, and so forth. But there's been a carve out for news gathering organizations. So what we've done with the news gathering organization piece for the residency requirement is just co-opt that definition of news gathering organization. We are informed that the Attorney General's office, which is a primary decider and enforcer and educator on Kentucky's Open Records Act in Kentucky, is urging and will urge leniency for public agencies in enforcement of this rule. It's going to be interesting to see what agencies do with this. I know of some agencies that have basically said they're not going to change the way they operate because the administrative burden of differentiating between residents and non-residents is probably greater than the administrative burden of just continuing to provide records to anybody who requests them. And I think the cynics out there, and I count myself among them certain times, are speculating that what might happen is if public agencies start being very difficult or stringent on the residency requirement, is that folks from other states who want to make open records requests here will just use someone local as their agent or their go-between to make an open records request. I know we have seen that in other states where residency requirements have been added. I think, and Amy, tell me if I'm wrong about this, in Tennessee it's illegal technically to do that, isn't it?
It's not illegal, but it's discouraged. And in Kentucky, legislators actually sort of promoted the idea that if you were troubled by this provision of law, you could use this local straw man to get these records. So there's definitely a difference in approach between Tennessee and Kentucky. And Tennessee is the state that's been most plagued by this issue, this residency requirement.
So if you're an entrepreneurial sort, maybe you want to start a little cottage business making open records requests for out-of-state requesters so that the residency requirement doesn't stand in the way. And as Amy said, there's nothing in the new statute here in Kentucky that forbids that. Although agencies might start looking behind that and inquiring, but that's a difficult thing to administer and police. So there are also, we'll turn over to the second portion of the new laws that take effect next week. Additional requirements for agencies and for requesters on really the nuts and bolts in the process of making and honoring open records requests. We will still have what we've always had in Kentucky, which is the ability to make your own open records request in writing, with your name, what you're requesting, and so forth. But the addition here is that the Attorney General is going to be promulgating, I think very shortly, an emergency regulation, as I understand it, just as a mechanism to get out this standard request form. I think the idea is that it's a standard form so that the things like residency, commercial purpose or non-commercial purpose, what you're requesting, name and address, and means by which you want to obtain records is all there in a standard form and doesn't have to be deciphered or interpreted by the agency. Like, if we all did our own open records request forms, they would all look different probably. So I think that's the idea behind it. We'll see how it plays out and whether and to what extent agencies really push the standard form or rely on the standard form, and whether requesters do.
And to the extent it's useful to know this, the Attorney General has told the coalition that he will promulgate an emergency reg on the 23rd, simultaneously promulgate a standard regulation that will permit a period for a formal public comment. If anybody has concerns that it goes beyond the parameters of what the legislature specifically set forth could be included in the request form, there'll be an opportunity for public comment. But so that we have that piece in place on the 29th so that agencies can discharge their duties, we will have a standardized request form that will be promulgated by the Attorney General by emergency reg on June 23rd.
Yeah,
Sorry.
it really is a placeholder.
Yes.
While the full-time request form is borne out, but we may end up seeing them be very, very much the same. Because I know the Attorney General's office has put some effort into reaching out to various agencies and interested groups to try to make this initial start on the request form as good as they can, I think. And by the way, I don't know that we mentioned this when Amy says the coalition. We are both directors of the Kentucky Open Government Coalition, which is sponsoring and providing today's webinar. So that's the standard form. We still have the, as I said, the traditional way of doing things that includes just a description of what you're requesting, your name, your signature, and your mailing or email address where you want the records. The open records law requires a, quote, precise description for documents that you request be mailed or emailed to you. That's sort of a twist. It's sort of in the interpretation of what precise means, because oftentimes, I don't know what your experience has been, Amy, but oftentimes I see people making open records requests and they can't make a precise description because they don't know precisely what they're asking for. In other words, you don't know what you don't know. You want records that you think exist, but you don't know what they're called or where they are, because if you did, you'd probably already have them.
Right.
It's a little upside down.
Yeah, I mean, still with regard to on-site inspection of public records, the standard of specificity is lower. A description will suffice. But if you're asking that records be emailed or mailed to you, then you do need to be as precise as possible. And I think a lot of some latitude has been granted during the pandemic because agencies have not been permitted to allow people to come in and inspect records. But it's a gray area, absolutely.
Yeah, and we also have, you'll see at the bottom bullet point, the 5 business day issue, which has traditionally been 3, right?
Correct.
And but when I say traditionally, over the last year and a half during the pandemic, it's actually been even longer than that because of the emergency regulations. So, and where do we stand on that, Amy? I think that even though COVID restrictions have been lifted for many things, we're at least arguably, we're still in the realm of the COVID emergency regulation in terms of the extended time period, right?
Yeah, I think a lot of this will be resolved when the Supreme Court rules on the recent case that I believe it pitted the Attorney General against the governor. Or it might, anyway, there was a recent oral argument that will resolve some of these issues. But for the present, the state of emergency is still in effect. It has not been lifted. That is absolutely 100% correct. And therefore, the 10-day deadline arguably still applies. So if I were urging a client to exercise an abundant caution, I would probably say 5 business days. But 10 days appears to be the current rule, and it really is that confusing because this has just been a chaotic situation with all this litigation.
So in addition to what the law requires, we also recommend you include these things in a request. Obviously dating it, if we are going to have the issue of the time frame for an agency to respond, dating your request helps. Probably not as big a deal in an email, which will automatically be dated, but in a handwritten request that's mailed, you'll definitely want to include that. Obviously, whether you want your records by mail or email or otherwise, or whether you want to review them on premises, That can make a difference both in terms of the timing and also in terms of any fees, copying fees that you're asked to pay. The commercial, non-commercial purpose statement, this will, I think, almost certainly be part of any standardized form that ends up being promulgated. And I think the current iteration of the proposal has the definition of commercial purpose, which is not the most intuitive definition, I think. It also has carve-outs for news gathering organizations, for folks wanting to use records for litigation purposes, and so forth. So oftentimes, if you're doing your own request, not on the standardized form, if you go ahead and start by saying this is a non-commercial request or a commercial request, you may save some time and headache in having to go back and forth with the agency about that, because we do see that from time to time. And then, of course, the residency requirements we talked about, you'll want to, if you do your own records request and not use the form with the checkbox, you'll want to go ahead and put that you are a resident and probably specify how you're a resident. You know, I live in Kentucky, or I work in Kentucky, or I'm a business that owns property in Kentucky, so forth.
Yeah, the standardized request form that the Attorney General will develop has a checkoff boxes so that you'll just be able to check a box, but that's why we've given you the statutory citations if you need those to communicate to the agency that you do qualify as a requester under this provision of the residency definition.
Yes, and I forgot to mention as we were having our technical difficulties at the top, if you are feverishly making notes, don't worry. We will make this PowerPoint publicly available. We will provide materials, including a cheat sheet with the highlights. This PowerPoint, we are recording this video, so we hope to be able to post that publicly online as well. And most importantly, from our perspective, we'll be sending out an evaluation for your feedback on today's presentation, any topics or issues that you'd like for us to focus on in the future. That's very helpful for us. All right. Next slide. I'll skip through. Commercial purpose. You'll see this. We won't spend time on it. This is not new under the law. This has been the law for many, many years. The difference between commercial and non-commercial purposes for open records requests really just boils down to whether the agency can charge a staff fee for the request.
And we included that only because if there's any concern, we're trying to be proactive about what impediments folks might encounter as this new law rolls out. So we're suggesting that proactively you might want to include these things just to avoid those impediments. You should certainly indicate that you're a resident, and ideally you would indicate under what statutory provision you qualify as a resident. But then again, we're probably being a little bit overly concerned, but this is just a good suggestion. This is best practice.
Yeah. So you've got here just a sample of a self-prepared open records request that we put together that tries to follow our recommendations. You'll have that on the PowerPoint for your reference. The standardized form it's not on the AG's website yet, but it should be once that initial form is decided upon. It should also be posted with each public agency along with their internal rules and regulations. We don't often see that, even though that's really been required by the law for years. So I don't know if this is a catalyst to make sure that agencies take that piece more seriously, or whether this will sort of fall on deaf ears like we've seen in the past.
It should be a catalyst, but to actually finally recognize that the law is, taking advantage of technology and encouraging agencies or requiring agencies to post these materials on their website is a big step forward. Even though technically we probably should have done it 20 years ago. The bottom line is, you should see broader compliance, and if you don't, it's going to be problematic for that agency.
In addition, here we have the methods for open records requests. We've got the ones that we've always had. They've added email in this new law, and part of the website posting, because email can be so prevalent the agencies are supposed to post on their websites what their official email address is for open records requests. Most agencies, I don't know what your experience has been. Most agencies, in my experience over the last 10 or 15 years, will pretty readily accept email open records requests, even though they have not, until this law takes effect, been required to do so.
Yeah, we thought they were required a couple of years ago in a bill that was introduced and passed by Senator Will Schroeder, but that was a bit of a muck-up. It didn't quite work out that way. So this is supposed to clarify that agencies are mandated to accept email requests, and they have put these mechanisms in place to facilitate that.
Here's some of the background we've alluded to, the long-standing requirement to adopt and post rules, which I think has not often been followed by agencies. It's really there for reference material. Here's what the rules are supposed to include. Again, I think this email address issue is going to be a catalyst to hopefully spur some public agencies to be more proactive with getting this stuff posted out there, but that is yet to be determined. We'll see what happens in July.
And I will say, I don't know what this is going to literally look like. If a physically posted rules and regulations, which is what the law since 1976 has required, posted rules and regulations in a prominent location accessible to the public, meaning a hard copy set of rules and regulations. Part of those rules and regulations now will include a copy of the standardized request form. I have no idea what that's going to look like. I questioned that all through the session. What does that look like when you're posting a hard copy in a physical location in your office? Obviously, with the web posting, it won't be as complicated, but I will say that the web posting is a real step forward for Kentucky. I mean, if there was a positive about House Bill 312, it is that it finally makes clear that email requests must be accepted. The Attorney General has already made clear that that is absolutely going to be his interpretation, and there's a footnote cited in the previous slide from a very recent opinion where he said there is no mechanism for denying an email request now. And so again, we have two positives. We have, using technology to expand public awareness of what the requirements for filing an open records request are. These posted rules and regulations, both physically and electronically on the agency's website. So that is a positive, I have to say.
Yeah, here's the slide on the 5 business days. Again, we are still in this sort of limbo area with the emergency regulations that are out there on the 10. But this, at some point, presumably, the COVID stuff will go away, and this will be the new norm, 5 business days as opposed to 3 business days. Which, frankly, many agencies take longer than 3 business days pre-COVID, in my experience, and there has not been, although oftentimes the Attorney General will point out that it is a violation to take longer than the 3 business days. There's not really much else to do on the enforcement side there. So in some ways, a paper tiger. All right, next section that we'll talk about, and we're running short on time, so we'll zip through this, are the new exemptions. Again, these take effect next Tuesday, and I assume that they will take effect for any requests made Tuesday or later. So it'd be interesting to see what the position is if I make an open records request next Monday, even though the agency doesn't have to respond to it until after the law takes effect. Will it be grandfathered in the exceptions? One of the big carve-outs in the new exemptions is for the General Assembly and the LRC, which is an arm of the General Assembly. They have, is it an overstatement, Amy, to say that they have essentially carved themselves out of the Open Records Act in part?
I'd say in whole.
Okay.
I would say in whole. What they've limited access to under the new statutes is essentially the stuff that is available on their website. So those are deemed public records. Everything else is deemed to be not a public record, and you use a different mechanism for requesting those records, challenging a denial of those records, and there is no right of appeal to the court. You're basically appealing to the Legislative Research Commission as a body of 16 elected legislators. And so essentially they have excluded themselves from the open records law. What you can get from them through the open records law after June 29th is what you could get on their website anyway, by and large. Well, I will say entirely. So yeah.
And these are some of those legislative records that Amy was alluding to: bills, amendments, contracts, work orders, sort of the traditional, already public information that the legislature puts out in any event. One of the other new exemptions that takes effect next week is...
Actually, this one took effect on March 23rd.
This was the emergency.
Yeah.
Good point. This took effect already. The exception for photos and videos of particular crimes. There are some carve-outs here if you are a certain person with a stake in that crime, the victim, and so forth. You'll see it's victim's immediate family, lawyer or insurer, obviously officials who are investigating misconduct, or those who are under investigation for a crime. And of course, importantly at the end here, we say, however, nothing in the law prevents the owner or creator of the photo or video from publishing or sharing the photo. That would clearly be a First Amendment violation. So if you happen to be on the street and take a video of police misconduct and somehow a copy of that makes its way into a police investigative file, while it may not be disclosable under the Open Records Act by the police, you obviously are still entitled to share it with anyone.
And to give you a sense of what we're talking about here, the sponsor of this legislation, and I'll try to do this very quickly because I know we're running up on time, but the sponsor of this bill is from far western Kentucky. He's the home of the Marshall County school shooting, and he had concerns about disclosure of some student videos, camera videos that were made at the time of that shooting. What we tried to help him understand was, as expansive as this bill is, or this law is now, it could also prevent disclosure of a George Floyd video. It could prevent disclosure of a David McAtee video taken from a surveillance camera at the location where he was shot. And so we had really grave concerns about this. I don't think those concerns are universally shared. I believe these are serious. This is a serious exemption to the open records law that is a really unfortunate overreach. We'd also included an internal jail video that depicted a jailer's rape of physical assault rape of an inmate. So we've got some problems with this bill, but it's a law, so we're going to live with it.
Yeah, and this one, as Amy corrected me earlier, has already been on the books and in effect for a few months. I've not seen any cases that have dealt with it yet. Then we've got the two other ones that I think are relatively minor. Or at least I hope are relatively minor. The first applies to public defender client and case files. I think what often happened in the past is that inmates or convicts who, pepper the DPA or others with a bunch of open records requests for their case files and their information got a bit frustrating. But the reality is this probably doesn't impact most people, just because most of that case file information would be subject to attorney-client privilege or work product protection, except for things that are already public anyway, by which I mean court pleadings, court files that are filed in a judicial record. So it's a pretty minor twist, I think, this exemption. And then there's the, to me, sort of a head scratcher, a new exemption that talks about public records or information which federal law or regulation or state law, you'll see is highlighted there, prohibit, which on the surface really is what the law has always been in Kentucky. But there's a little bit of a wording change, that instead of state statute or enactment of General Assembly, now it says state law. So there's a question whether this is going to allow agencies to promulgate regulations to get out from under the the Open Records Act. All right, we will.
We have some questions.
We appreciate everybody staying with us. I know we got started a little bit late, so, and I apologize for going over. We're going to get into the questions now. I do know that we have a number of those.
Okay, so first of all, and Jeremy and I'll just give you just quickly as we can the answers to these questions. First of all, our colleague Scott Horn, another co-director of Coalition, will be sharing all of this information with you. We will be posting this video. So please know that, this is our first effort, so we're really excited about it. We're really hoping to get some good feedback from folks, but not of the electronic kind that we just had, but okay. All right. CLE credit. Yes, we have an application pending for CLE credit. It obviously will be a half hour because that's what we anticipated, but we will be notifying you very quickly, and our colleague Scott Horn will let any lawyers who indicate that they want that notification. There's a mechanism for doing that when you signed up. You can get CLE credit. We're pretty sure that's going to be approved. Can we also charge for scanning documents or printing documents in addition to copies? The cost is the same as a copy. So I guess this is an agency individual who's asking if they can charge for scanning documents or printing documents in addition to copies. I'm not sure I understand the question. Basically the statute permits you to recover your actual cost. If you incur no cost in scanning a document, then you can't assess a charge.
Yeah, there will be a difference if it is a commercial purpose request for staff time, as we talked about.
Yeah, and by and large, we're assuming our audience is primarily members of the public who rarely would have a commercial purpose, but to the extent there would be a commercial purpose, yeah, you could recover your staff time. But let's just proceed on the assumption that if you email copies, if you scan copies and there's no cost associated with that, you can only recover your actual cost. Okay, so there's also a question from a Cincinnati journalism media outlet. Can you once again recap the rules for out-of-state media journalism outlets? It's basically everybody,
Yeah, if you are a news gathering organization or qualify as a news gathering organization under that statute, which is fairly broad. I've litigated that in the Court of Appeals, and they determined it fairly broadly to apply to all kinds of news gathering organizations. Then you are, even if you have no presence, physical or otherwise, in Kentucky, you are still treated under this provision to the Act as a Kentucky resident. So you should be good. It should not impact your ability to request records, other than that you may have to check a box and explain that you are a news media organization.
And I will tell you, that was not the case when the bill was originally introduced. It only applied to Kentucky media. That was one change that was made. That was an accommodation that was made. So, okay, let's see here. I'm trying to, I know we're over time.
There's one question about the cheat sheet. That will go out with the materials, the evaluation. So look for that in your email.
Okay. So is it 5 business days from receipt, or does the 5 days start the day after receipt? The Attorney General has always construed the 5 business days to start after the date of receipt. I don't know. Yeah.
The day that the agency receives it is day 0.
Yes.
So the next day is the first day after. That's a good question because it can be confusing.
Yeah, there is a statute that we always refer to in the Attorney General's office with regard to the timing with the receipt of documentation, and there's a long line of opinions affirming that the day that it arrives, even if it arrives at 9 a.m. or 5 p.m., that day is excluded from the calculations. So
well, there's a good question about body cam footage showing a fatal shooting by police, and there is a different treatment here for body cam footage.
They expressly carved out body cam video. Yeah, so that is still going to be accessible under the rules that apply. There's a separate statute, I think it's 61.168. that has governed access to body cam videos for some time. I think that's the statute.
Yeah, none of this is to say that body cam footage is going to be free and easy and really simple to get a hold of. It's just that this law change does not apply to that. We've seen over the years, since body cams have really become more prevalent, there are exemptions that have applied to body cam footage, both specifically and the general exemptions, like the privacy exemption and so forth. So those will remain in place.
And I did want to mention, there's a good question here. Can an agency offer its own form in addition to the AG standardized form? I would think the answer is no. I think the idea with the standardized form is that we have specific parameters on what an agency can request. And therefore, I think it will be interesting. I don't think that I think when the legislature enacted this provision, they didn't even provide that a person could still submit his own request. They were thinking exclusively of a standardized form that everyone would use across the board. So the idea that an agency might do their own form, it's a little bit questionable, and I would say highly questionable. I think people need to either use the standardized form or draw up their own request form as they would have in the past. However, that is not clear. I think the standardized request form is intended to be the form.
I think that's right, the intent, but if you look at the law itself, I don't read it as prohibiting an agency from offering its own additional form. But once again, agencies won't be able to insist that be used. You still have the ability to do your own request or use the state standardized form.
And certainly including no more information than the legislature expressly permitted under this statute. So, there's additional information that this one requires. The standardized form statute does require submission of a little bit more additional information. It originally required submission of a lot more information. And again, they retreated from that. But by the same token, if I were developing my own form, which again, I don't know that that's contemplated by the legislature, but the bottom line is, if an agency does that, I would look at the statute that relates to standardized forms and the Attorney General and limit it to just that information.
Yeah, if your public agency is required to give your mother's maiden name and your social security number and a bank account number to make an open records request, obviously that's over the top and not contemplated under the law. But if they just want to send you a form that has the same information as the state form, I think they can do that. But the whole idea with the standardized form is to make that unnecessary, I think.
That covers business day. We are open 7 days a week. Can you define business day?
Oh, that's a great question. Everybody's business day definition is a little bit different, but under the Open Records Act, what we're talking about is non-weekend, non-state or federal holidays. So whatever days that public agency is in, open business.
I think the statute actually says excluding Saturdays, Sundays, and legal holidays. So even though you are open, I think you technically could exclude those days. I don't think I've ever known, except I could imagine a law enforcement agency is open. Their business offices may not be open 7 days a week, but yeah. I mean, the statute,
right.
Yeah, we've used the word working or business day, as a sort of shorthand for Saturdays, Sundays, and legal holidays. But the reality is, I think the statute actually is excluding Saturdays, Sundays, and legal holidays.
I think it's a really good point, because you think of some agencies that, for example, state universities, they often shut down for a few weeks over the winter holiday. And so it can't be the flip side. They can say, well, it's not a business day for us, December 20th through January 2nd. But under the law, as long as it is not a legal holiday or a weekend, those days count, in other words. Well, we have gone over our time. We really appreciate all of your interest and your participation and the great questions. Look for your email with the materials. Check out the Coalition's website, the Coalition's Facebook feed, and so forth, Twitter feeds.
Our website's not up quite yet. Our good friend Scott Horn is working on that, but he does have a full-time job, so you have to be patient. It's going to be an amazing website. We are very excited about it.
We really hope to be a good source of resources and material for the open records requester and agency out there, all who are interested in open records compliance. Again, look for the materials in your email. Please fill out the evaluation. Let us know the good, the bad, what we can do to cover other topics, and give you what you need in terms of government openness. That's what we aim to do. So with that, we will sign off. Everyone have a super Monday. We really appreciate you guys. Take care.